As mentioned at the end of our last section, we're now going to begin discussing the general prohibitions. And as we'll see in a moment, we're talking about specific conditions, specific scenarios under which exports or re-exports are prohibited without the proper license authorization. So let's get right into it. This is yet another look at our export control decision tree. And we're not going to go into too much detail here, but we did want to point out a couple of key components as they relate specifically to the general prohibitions. Now, when we first introduced the decision tree, it was related to topics like, is an export subject to the EAR? Is an item subject to the EAR? We saw that at the very top of the decision tree. Now we're going to move down a little bit lower and delve just a little bit deeper into the topics surrounding the general prohibitions. So as you'll note right in the middle in our rectangle, and we had briefly mentioned this in our previous section, one of the first questions we have to ask ourselves on the decision tree, is our item classified under an ECCN on the Commerce Control List? And right below that, you see reference to the first 3 general prohibitions. There are 10. They're talking about the first 3 here. So as we also discussed previously, albeit briefly, moving to the right, if the answer to that question is no, it's EAR 99. Move to the left. If there is an ECCN, you proceed from there. But what we're really interested in pointing out here is not only that first rectangle with the circle around it, but to the lower right of that, making mention of general prohibitions 4 through 10, and not to the left of that, also making mention of general prohibitions 4 through 10. Do they apply? And if they do, what's the direction of the decision tree? And if they don't, what is the direction of the decision tree? We're just introducing and pointing out general prohibitions in this version of the decision tree. So let's move on. Getting down to the nitty-gritty of the general prohibitions, if an export, re-export, or activity is subject to the EAR, there's that terminology once again, the general prohibitions found in Part 736.2b of the EAR must be reviewed. The general prohibitions, as we see in our second bullet point, describe those circumstances under which an export, re-export, or related activity cannot take place without an export license or other authorization, meaning a license exception. So let's refocus on bullet point 2 and talk about the circumstances under which an export, re-export, or activity cannot take place. That's what the general prohibitions tell us. The 10 different prohibitions that do not allow an export without a license or another authorization. Moving on to our third bullet point, as we'll see in a moment, the obligations under the general prohibitions are driven by 5 types of information described in EAR Part 736.2a. And hopefully, these themes that we'll look at right now start to make more sense. The general prohibitions and determinations of applicability. How are the general prohibitions applied to specific export circumstances? Well, the applicability of the general prohibitions are based on the 5 types of facts surrounding a specific transaction. Number 1, the classification of the item. Does the item have an ECCN citation on the CCL? Second point is the destination. Where is it going? The end user. Who is going to be using the item? Second to the last sub-bullet point, what is the end use? There's that dual use theme again resurfacing. And the 5th point is related to conduct of the parties to a transaction, the seller, the buyer, consignee, and their particular conduct as it relates to financing of a purchase, the contracting for a purchase, freight forwarding activities. Those are just some examples of what we mean by conduct of the parties. Now we're going to bring up our decision tree again and reiterate this whole idea of, is our item classified under an ECCN on the CCL, and general prohibitions 1, 2, and 3. That's what we're going to be talking about here. And like any decision tree, the answer to a question, and it's binary, it's a yes or a no, will lead us in different directions. We'll get more into those directions later on. But ultimately what we're looking at, just to move ahead just a little bit as it relates to the decision tree, are 3 different scenarios, and you'll see them in the middle here. The first one is no license required. We'll talk more about that later on. Second one is to be able to use a license exception, which we will also elaborate upon. And then the bottom, after we go through the entire decision tree, we might find ourselves in a situation where we have to submit an application for a license. We've exhausted all the possible exceptions. We went through the general prohibitions. It's likely that some of the prohibitions apply. We find ourselves in a situation where we have to submit an application for a license. That's getting a little ahead of ourselves here, but just wanted to paint the canvas in a little broader fashion. So when we talk about it specifically, it won't be the first time that we're discussing it. But right now, let's focus on those general prohibitions 1, 2, and 3. General Prohibition 1, pretty basic. The export and re-export of controlled items to listed countries. So we're talking about controlled items show up on the Commerce Control List with a corresponding ECCN with controls in place to specific listed countries, which we'll also be discussing further down the road. So basically, second bullet point, no exports are allowed under General Prohibition 1 without a license or license exception if, and these are the conditions as it relates to General Prohibition 1, the item is controlled for a reason indicated in the applicable ECCN. So we have an item, we know it has a corresponding ECCN. As we mentioned on a couple of occasions, there are going to be reasons for control. We saw anti-terror, we saw national security, we saw surreptitious listening. That's what we're talking about here. The item is controlled for a reason indicated in that specific ECCN. We were looking at 5A001, 3A001, and 6A003, if again my memory serves me. In each one, there are reasons for control listed there. Second sub-bullet point, no exports allowed without a license or license exception if export to the country of destination mandates a license for the control reason shown on the country chart. We haven't looked too much at the country chart just yet, but you will recall we had a few excerpts of it. It's that famous or soon to be famous X in the box principle. So we're looking for reasons for control and an ECCN citation, but we also have to know the country that we're exporting to and determine if the reasons for control shown in the ECCN show up as an X in the box for the country that we're specifically exporting to. So we're bringing together, under General Prohibition 1, the CCL and the country chart. Pretty important stuff. General Prohibition 2, we're talking about the re-export and export from abroad. This is different now, of foreign-made items incorporating more than a de minimis amount of controlled U.S. content. We need to stop and explain a couple of things here as it relates to General Prohibition 2. We're talking about re-export or export from abroad. So it's not just the United States, it's other countries as well. U.S. Export Administration regulations apply to items subject to the EAR in foreign countries. That's what we're talking about here. What we're also talking about is items that incorporate more than a de minimis amount of controlled U.S. content. That means a particular item with an ECCN incorporated into a product. Perhaps we can make it a little bit more visual by looking at our image here that has a specific limit as to how much content of that controlled item can go into a product. That's what de minimis means. The maximum amount of an item that can go into a product. So we're talking about exports and re-exports from abroad that incorporate more than a de minimis amount of controlled U.S. content. So let's move on to our second bullet point. Specifically, no re-exports or exports allowed without a license or license exception if, as we said, the item incorporates more than the de minimis amount of U.S. controlled content allowed. Second sub-bullet point, the item is controlled for a reason indicated in the applicable ECCN. This harkens us back to General Prohibition 1 as well. The item we're talking about and the corresponding ECCN citation is controlled for a reason indicated in that ECCN. Final sub-bullet point, export to the country of destination mandates a license for the control reason shown on the country chart. So here we are again, looking at the CCL and the country chart, but in this context, talking about re-export and exports from abroad of a foreign-made item incorporating more than a de minimis amount of controlled U.S. content. So the same principles apply as we talked about in General Prohibition 1, sub-bullet point 2 and 3 here, but it's specific to exports and re-exports from abroad of foreign-made items that incorporate more than a de minimis amount of controlled U.S. content. Items that are going into the production of a final product that are controlled under the Export Administration regulations. General Prohibition 3, re-export and export from abroad of the foreign-produced direct product of U.S. technology and software. So now, we're still talking about re-exports and exports from abroad, but we're dealing with the result of using controlled technology and software, intangibles, as we had discussed during the conversation on deemed exports. So to reiterate, General Prohibition 3, deals with the re-export and export from abroad of the foreign-produced direct product of U.S. technology and software. This foreign-produced product could not have been made without the U.S. technology and software component. So, second bullet point, no re-exports or exports are allowed without a license or license exception if that foreign-made item is the direct product of technology or software that requires a written assurance as a supporting document for a license. We'll talk more about what those supporting documents are a little bit further ahead. But General Prohibition 3, it's that intangible component, re-export and export from abroad of a foreign-produced direct product of U.S. technology and software. The intangible component is the technology and software, but we're talking about the physical export or re-export of foreign-produced direct product that are a result of U.S. technology and software. Continuing on with General Prohibition 3, second bullet point, no re-exports or exports allowed without a license or license exception if that foreign-made item is subject to national security controls under the applicable ECCN. So we have to be dealing with a specific citation, ECCN citation, and under that ECCN, a reason for control has to be listed as national security. Second sub-bullet point, no re-exports or exports allowed if the foreign-made item is the direct product of a complete plant or a major component of a plant. All right, let's take a look at an industry vertical that helps to illustrate compliance with General Prohibitions 1, 2, and 3. We as an exporter have to check and make sure that we are not in violation in any way of General Prohibitions 1, 2, or 3. We also have to make sure we're not in violation of Prohibitions 4 through 10, but we'll get to those in just a little bit. So we're going to be using as an example that same maker of telecom equipment that appeared in our previous examples, the 5A001 example. This particular company also exports low technology, widely available switching equipment for that telecom industry. Emphasis on low tech, widely available. As part of the company's normal export compliance procedures, the company uses the consolidated screening list to vet a new customer in Malaysia and also determines that the low-tech equipment the company wishes to sell is not in violation of General Prohibitions 1, 2, or 3. What is their next step in the compliance process? Well, before we move on to that, let's refresh our memory about what General Prohibitions 1, 2, and 3 really are. But before we even do that, let's make mention and discuss a bit this whole consolidated screening list conversation, which will come up in detail when we talk about sanctions and other topics related to the vetting of overseas customers or potential customers. Related to what we discussed briefly in some previous slides, restricted party screening. How do we as a company make sure that throughout the entire sales export process that we're not dealing with parties overseas that have been prohibited to do business with the United States? One of those tools is called a consolidated screening list. It's actually provided on export.gov and is a powerful tool because what it really does is consolidate all these different lists of bad guys, basically, that the government has put together, people, companies, government entities, etc., puts them all together in a consolidated format, and we can use that tool without having to go through each list separately. That's what we mean about this consolidated screening list. More on that later on. But for now, let's focus or refocus on what we mean by not in violation of General Prohibitions 1, 2, or 3. Well, you'll recall, we hope, that General Prohibition 1 deals with exports and re-exports of controlled items to listed countries. So it's what the product is and where it's going. And no exports are allowed without a license or exception if the item in question, in this case, our low-tech, widely available switching equipment, the item is controlled for a reason indicated in the applicable ECCN. Well, if this company is stating that they're not in violation of General Prohibitions 1, 2, and 3, by definition, it would have not had an ECCN in the Commerce Control List. As it relates to General Prohibition 2, you'll recall that this deals with the re-export and export from abroad of foreign-made items incorporating more than a de minimis amount. Well, clearly, for purposes of this example, the telecom equipment was made in the United States, at least assembled in the United States. So there wasn't a re-export or export from abroad, so that takes care of General Prohibition 2. As it relates to General Prohibition 3, you'll recall, that deals with the re-export and export from abroad of the foreign-produced direct product of U.S. technology and software. Because this switching equipment is assembled in the United States, General Prohibition 3 doesn't apply either. So now we can comfortably move on to answer the question, what is the next step in the compliance process? Well, as noted, and we'll see it in just a second, in the export control decision tree, if an item is not classified under an ECCN on the CCL, and there are no violations of the first three general prohibitions, which we just articulated, the item falls under EAR 99, which is a designation for an item that falls under the Department of Commerce BIS jurisdiction, but that does not appear on the Commerce Control List. That's a fancy way of restating what we just said. No ECCN, doesn't show up on the CCL, doesn't violate General Prohibitions 1, 2, or 3. We're off to the races, at least as it relates to the next step, which is to answer the question, which is to determine if General Prohibitions 4 through 10 apply. We're getting a little ahead of ourselves because we haven't studied General Prohibitions 4 through 10. We'll be doing that in a moment, but that's the answer to the question. What's the next step? Well, determine if General Prohibitions 4 through 10 apply. That's where we'll stop for now on this particular export control decision tree. When we pick up in the next section, which will be section 21, we'll be discussing in detail General Prohibitions 4 through 10. We'll be back shortly.